All right, everyone, I'd like to introduce the third panel of the day, which is going to talk about expertise in data and getting smart on crime. To my left is our moderator, Sandra Mason, who's an NYU Law alum and assistant professor of law at the University of Georgia School of Law. And to her left is Judge Patty B. Saris, who's the Chief United States District Judge in the District of Massachusetts, and actually is also the former chair of the United States Sentencing Commission from 2011 to 2017. And to her left is David Ball, who's an associate professor at Santa Clara University School of Law. And then at the end, we have Kay Knapp, who is a consultant with the Rabina Institute of Criminal Law and Criminal Justice at the University of Minnesota Law School, and also served on the Minnesota State Sentencing Commission.
Thank you so much, Courtney. Thank you to the NYU Law Review and to NYU for having us. It's a pleasure to be here. It's a pleasure to moderate this panel on expertise as a remedy to the pathological politics of the criminal justice system with people who have so much of it. So we're gonna jump.
Pathology?
So much expertise, to be clear. We're going to jump right into the discussion with a question that each of these panelists will take a few minutes to answer, and then have a more free-flowing conversation before we open it up for your questions. For those of you, if there is anyone in the audience who hasn't read the book, I just wanted to begin by reading Rachel's core proposal in Chapter 9. This is from pages 168 to 69. Rachel writes, "The key is to create and employ expert bodies that use empirical data and studies to guide their decisions about criminal justice policy. The specific model of expertise could vary. Jurisdictions could opt to use one umbrella agency that is responsible for all criminal justice policies within the jurisdiction, from bail to sentencing, collateral consequences to prison conditions and programming. Or jurisdictions could use a number of such agencies. Under either approach, jurisdictions must make sure that any agency setting criminal justice policies is held accountable for the costs it imposes on the jurisdiction overall, and that it uses the least costly options for addressing a particular issue." So the book discusses sentencing commissions as one possible model, and a theme of the chapter is the necessity of insulating any expert agency from politics and the demands of the popular will. The question we'll start off with is that possible? Is it possible to insulate an expert agency from politics? And I'll look first to you, Judge Saris, to tell us a bit about your experience on the U.S. Sentencing Commission.
Well, thank you very much for inviting me. I must say, I served with Professor Barco on the United States Sentencing Commission. So when I heard she published a book about the subject, I ran right out to get it, and it was the last copy being sold at the Harvard Coop. So I'm hoping that lots of people are reading it and that will have an impact. So as you heard, I became chair of the Sentencing Commission back in 2011 at probably what was close to the peak in the mass incarceration crisis. We had the largest number of federal prisoners at that point. We had about 217,000 in the Federal Bureau of Prisons, and it was eating up about a quarter of the Department of Justice budget, and that didn't even begin to deal with what was happening nationally. So very much when I went down there, I wasn't a total newbie to Washington because I'd worked for Senator Edward Kennedy, who was one of the authors of the United States Sentencing Commission, and I'm thrilled that the First Step Act got such a large number of votes. The actual creation of the Sentencing Commission was passed by the Senate 100-0. And it was viewed as really a no-brainer, very few dissenting votes in the House as well, that you should have an expert commission. And so let's look and see, has that worked? Has it been insulated from politics? I don't think a sentencing commission can ever be completely isolated from politics. That all three branches of government care too passionately about the sentencing issue. It's a shared power with the legislative, executive, and judicial branches. We all care about it. But what's necessary is maybe not to completely insulate it, but to mostly insulate it and to rest on data. When I got down there, I had two big surprises. The first was how politically engaged, shall we say, that the Sentencing Commission was, how much politics did play a part in it. And I'm going to let me count the ways. But the other piece of it was how many really dedicated statisticians, criminologists, lawyers, people on staff who are really committed to trying to create sentencing policy based upon data. And so the question is, well, how did these two things engage? The Sentencing Commission was established to have 7 members on it. It was intended to be bipartisan, so that the president pretty much got 4 votes, and got to nominate 4 people, and then 3 of them were, the president nominates actually all of them, but 4 were going to be the controlling party and 3 not. So when I was there with 4 Democrats and 3 Republicans. And not only were you nominated by the president, but you're confirmed by the Senate. So you have to go through a confirmation process. When I went down for my confirmation process, Senator Kennedy was no longer alive. And I had gone through, I flew through becoming a federal district court judge and sort of thought that would happen when I was becoming chair of the Sentencing Commission. It didn't happen that way. So in confirmation, I was being asked a lot of tough questions about sentencing, and in particular by Senator Jeff Sessions, who was still on the Senate Judiciary Committee at that time, pressed me very hard on, I'd say I was for drug courts. Well, how do you know they work? Really pressing. And he wanted to know positions on issues, as did the other members of the Judiciary Committee. The second way, and so from the get-go, you understand how clearly engaged the Congress is, particularly the Senate, is on who's on the Sentencing Commission. Next thing that happened to me is our budget. We were asked about our budget. How are we spending our money? Well, we produce our documents. How much are we spending on this, that, or the other thing? So our budget is controlled by the Congress. Third thing is, probably one of the least pleasant things that I've gone through was an oversight hearing. I was less than a year on the job, and Congressman Sensenbrenner chaired a oversight hearing where I was really just really a novice at it, and I hadn't understood the intensity of it till he started off the hearing saying, "I believe in the power of impeachment." And I went, oh my gosh. I'm a brand new chair, and I'm talking about the power of impeachment. And several of the congressmen went after me with questions like, why are judges in Massachusetts so liberal? And it was concerned about why don't I believe, why, about the Booker opinion and whether mandatory sentencing was preferable. And it was a pretty rough hearing, I have to say. I went home and told my husband, I said, I can't believe I agreed to do this. I mean, why did I agree to do this job? But, and then before I go back, that did all turn around the next year, and I'll talk about that. And then there's everything that the Sentencing Commission did was subject to a legislative veto, which didn't happen very much, but was still a possibility. And lastly, and it's the hidden form of control that I'd like to discuss for a minute, which is the Congress has the right to and frequently does issue directives to the Commission on what they want sentencing penalties to be, for example, in the area of child pornography or economic crime. Their sense at a given time, and this is what I'm saying, is as to what crimes they wanted to be punished, usually more harshly. In fact, I'm trying to think if there was another example, but it's usually more harshly. And so at times, I mean, and when you say, can it ever be totally isolated, there is always going to be, and we can have a big discussion about some sense of retribution for certain crimes, whether it's child predators or economic crime or drugs in the opioid epidemic period, that it's going to make it really hard to ever fully extract it. But where I completely agree with this book is you need to try. You need to try and make criminal policy based on the data, have the statisticians, have the criminologists, and look at everything from juvenile justice policy to and I can discuss some of those questions that haven't before. What is recidivism? We studied that at great length and in great depth there. I mean, you have to have this with firm policies, like our primary goal is public safety. Yes, retribution may be part of it for some folks, but the primary goal is public safety. And how does this help? And we started doing it in the commission with prison impact statements and also with reports. I'm proud to say that our report on the mandatory minimums was the foundation for the First Step Act. A lot of the data and the proposals in there was incorporated therein, and we helped along the way with how would this proposal work and how would that proposal work. But along the way, you had to have had somebody who was going to step back, look at the evidence, look at who was published, and realize that the people being captured by a lot of these drug penalties was not the Miami Vice. Do you all even know what that is? the big kingpin, the big kingpins, yeah, a lot of them were the low-level street dealers and mules. So I would give a pitch for trying to insulate as much as possible, but if the answer is, can you fully ever insulate it? No, I don't think you can.
Okay, you've had a lot of experience working with state sentencing commissions. So is there a model? What's the best model of political insulation, and what common pitfalls have you seen?
Well, I will talk about Minnesota because it's the longest-lived commission. The guidelines from the Minnesota Commission went into effect in 1980, so it's been about 40 years. Just to give you a little background, Minnesota was the first state to have a commission established that was supposed to develop comprehensive, authoritative sentencing guidelines for felony offenses. And the commission was given a mandate to limit prison populations in that development. They were not given a blank check. They said, no, we do not want to have to build more prisons. So that was the key factor in developing guidelines, frankly. The commission had decided that they wanted to do guidelines that were proportional and with respect to harsher sanctions for more serious offenses and keep things very proportional. They also wanted to reduce disparity in sentencing, which was seen as the biggest problem at that point, is that some people got slaps on the wrist, other people got horrendous punishments for essentially the same crime. Much of that was blamed on the parole board, rightly or wrongly, and so there was a desire to eliminate the parole board and give judges the sentencing and have them actually impose sentences that would be served rather than having it second-guessed or make the real sentencing decision at the back end. At any rate, that decision to cap prison populations and limit them was instrumental in the success of the commission in being insulated from political pressure. It changed the discussion from let's lock up more people to which people should we lock up given limited resources. And it changed the nature of discussion tremendously. It was always a question of trade-offs. Yes, you can do that, but then you have to do something else that you may not like to do. So it was constantly looking at those kinds of issues. It was a zero-sum situation, and people had to make their choices. Both the commission did. Anybody arguing in front of the commission had to also be subject to those same trade-offs because it was in the enabling legislation. It gave the legislature, for the first time, effective control over prison costs. Up to that point, if judges sent people to prison, if the parole board didn't let them out, the legislature had to foot the bill regardless of what it cost. They didn't really have much of a choice. This put them in the control. They could choose to have harsher sentences if they wanted, but they knew the cost, and they knew they could limit it if they wanted to. So it was a huge thing for the legislature to gain that control. There were no more correctional free lunches, if you will. So that was a huge factor in depoliticizing because it was always about trade-offs. Second factor, somewhat ironically, I guess, that insulated the commission politically is that they had fairly politically astute commission members. They did represent the criminal justice constituencies, judges, defenders, prosecutors, corrections officials, citizens as well. But they had vast experience in the public arena, and they also had vast substantive knowledge about criminal justice. They were very willing to operate within the mandate of the legislature, which allowed them to create a very different system and a new system, even though they were very much a part of the old system of criminal justice and sentencing in the state. They could navigate, they could anticipate, and they could very credibly deal with anything any of the constituent groups threw at them because they were knowledgeable about it and they were part of that system. And so when a prosecutor would come, you have to do this, prosecutor on the commission would just say, come on, you know, that's not necessary. Or the judge could say, look, the sentences you're giving today are not really being served. The parole board's making the decision. You're just saying a number. Here, you're going to be saying the real sentence. So that experienced commission was very useful, and that has continued throughout the years with ebbs and flows over the 40 years, obviously, in terms of how innovative the commission members were willing to be, but certainly the initial commission had that going for them. The third insulating factor for the Minnesota Commission, and this is true for most state sentencing commissions, was data. The commission created a vast, comprehensive data set on felony offenders and the crimes they committed. That data was totally critical, both in the development of the guidelines and then also in protecting the commission from political pressure throughout the years. The data were used to assess the impact of every set of sentencing policies the commission wanted to consider, both in terms of who would be punished, what the prison populations would be, what the racial composition would be of prison populations, what the gender population would be in the prison population. That data was, again, critical in helping to limit prison populations. But it was also down the line so useful in dealing with the press, with the legislature. The data was credible, and the staff always dealt with everybody and the data honestly and with great integrity. And the commission was actually the first telephone call anybody would make, whether it be the legislature or the press, when something happened, when there was that outlier crime, when somebody wanted a law passed in terms of a new sentencing policy, a new crime. And so the commission often got to frame the issue. They dealt so well, I think, with the press in that even though they have deadlines and maybe analysis would be needed with the data, that the data analysis would usually be done in maybe 15 minutes, a half an hour, gotten back to the press so that they would always have their information. So those three things were the most important, I think, insulating factors.
Great. David, you can speak to this question if you'd like. Kay, also, it's really fascinating that you identified the cap and the clear objective as a central insulating factor for the Minnesota Commission.
Yeah.
Perhaps you could tell us a little bit about your thoughts.
Sure. Yeah, I mean, but before we get there, that was actually, I was planning on discussing that at the very end. I think my analysis of this would be, the first three questions would be about whether or not public safety is actually an apolitical goal. Question two is like, what are we maximizing when we're talking about what our goals are, or what the metrics of success are going to be? And then the third really is what counts as data, and I think that depends on our model of what, encourages criminality or overcharging or whatever you have. And so for the first question, like what is public safety? I'm going to borrow from both Bernard Harcourt and DeRay McKesson, Columbia Law professor and BLM leader, respectively, talking about public safety includes people feeling like they are not going to be harmed by the police. Bernard pointed this out when he was talking about the Giuliani administration, that yes, murders went down, and we can discuss causality if you would like, but also civilian complaints about use of force went way up. And so if you decide that public safety only means, sort of squeegee men and turnstile jumpers, then yeah, Giuliani succeeded in improving public safety. But if you say people should have a right to be able to call the police and not fear for their lives, especially if they're poor or black and brown, then it wasn't a public safety success. Imagine if Al-Qaeda or your criminal syndicate of choice had dumped lead into the water of Flint. That would be the crime of the century. And I also mention that because lead poisoning is a criminogenic factor if you're exposed to that as a child. But it wasn't. But isn't that part of public safety too, right? And it does have criminogenic effects. In California, there's currently a case that most of us doing bail work thought wasn't going to be important, and then when the bail legislation didn't turn out so great, turned out to be the most important thing, called In re Humphrey. And I wrote an amicus brief for, it was mentioned earlier, a group called Crime Victims for Safety and Justice. And in California, the governing law says bail shall be set for public safety, but public safety is not defined, and it is defined elsewhere in the penal code. And so we made the argument that Mr. Humphrey couldn't get drug treatment, and the California legislature had said that in the interest of public safety, we need to have drug treatment. California has also said, sort of ironically, George Deukmejian, who was one of the people who helped California build 20 prisons in 21 years, would have these ballot initiatives that were like the crazy all caps emails you might get from a conservative elderly relative that were like, we need more safety, we have to have more beds. And so we made the argument that having a heavy pretrial population is actually antithetical to public safety because it does need to be reserved for people who really need it, not just people who are too poor to be in there. So those are ways in which public safety, I think, is a very contestable and political question. The second question about what we're maximizing, and living in Silicon Valley either, I guess, makes you a real homer or an incredibly jaded cynic, and I'm in the latter category. Data works in tech because there's one maximand, and that is money. And even when it comes to future revenues, you can do net present value equations, but everyone agrees that more money is better if you're a corporation. But we don't even have a clear conception of that. Not only, we've talked a lot about retribution versus utilitarian goals, but even the utilitarian goals, deterrence, incapacitation, and rehabilitation, those aren't always compatible with each other, and they're not commensurate. So if we were going to say, well, your goals are only utilitarian and not retributive, then how much incapacitation, at what cost? We could give the death penalty for people who have only one passenger and drive in the HOV lane. I'm in favor of that. And that would deter people. But, I don't think that would be fair, right? And it wouldn't incapacitate the other jerks, who are doing that necessarily, right? If we're talking about, Professor Barco talks about, and if I call her Rachel, it's just because I like her. It's not because I, whatever. But, if we talk about re-entry, that is one thing we could be looking at, but I actually think we should focus on non-entry. And so there's an interesting debate, Kim Ogg, who was mentioned in the book as a reform DA, just came out with a request that we have 18,000 cases in Harris County, and so we need more prosecutors. And my response to that, along with another group of academics, was to say, that's an endogenous caseload. Pick whatever ones are most important to you and dump the rest. You don't get to keep on growing. You're the one charging. You're in charge of that, literally. So that's a question about what those numbers mean. If we talk about, disparities, would we rather have lower numbers, absolutely, of black and brown people arrested and sentenced, even if the numbers are still disproportionately that black and brown people get arrested and charged for that? So is it the levels or is it the sort of rates that we're concerned with, right? One answer to that, which I always tell my students, is arrest and prosecute more white people. That's not seen as very politically feasible, but that would certainly solve the disparity problem. And so, I just, and I think just one thing that's important to mention is sometimes we lose sight of the fact that, even something like the Fed, which, you mentioned as an example of your book, George Bush the elder, accused the Fed of being political in terms of when, the economy was stimulated and things like that, right? So these things can always be taken as being political, even if they're not, expressly political. Next question, the next thing I want to talk about, I just want to ask you all a question. So think about where you think the greatest gross property, the crimes with the greatest gross property value, what district of New York that's in. Just think about it for 10 seconds. Okay, everybody said the financial district, right? Because when we think of crime, we don't think about white-collar hotspots. We think about people stealing purses. But, Bernie Madoff stole like 5 million purses. And so I think if we're talking about data and we're talking about crime rates, we really have to think about what that means. James Clear, who's a criminologist at Rutgers, several years ago gave a talk where he said, look, we've had 40 years, 8 years of increasing crime, 8 years of decreasing crime, 8 years of increasing crime, 8 years of decreasing crime. When crime goes up, we need prisons. When crime goes down, prisons are working. And he raised the point that why isn't it that when crime goes up, prisons aren't working, and when crime goes down, we don't need prisons? Now, that's the same data, but what it means really depends on what your model is. So data do not have value in the wild, or for those of you who did philosophy of science, Karl Popper, all data is theory-laden, right? And so when we think about what our model is about why people offend, that will influence what kind of data we get. We know that people who've suffered adverse childhood experiences are way more likely to self-medicate in terms of substance use disorder, but we don't actually inventory people for adverse childhood experiences when they come into the criminal legal system. And there might be problems with that, but unless we collect that, we haven't thought to collect that data because the science has not been up there, but that is actually what's driving a lot of abuse of alcohol and other drugs. And so the last thing I guess I'll say, I'll skip over some of that stuff, but this question about, how do we ration and political pressure from who? And I'll just speak about this briefly, that I do think that it's important to think about which budget is counting, which decisions feed into that budget, et cetera, et cetera. There was a story maybe 10 years ago where a jail in Nevada was giving people they released bus tickets to go to San Francisco. Well, in Nevada, their crime, I'm sure, went down, but thanks a lot for that because I live in San Francisco. So there's this question of how do you unify the criminal justice system where the people who are making decisions basically are also, if the people who are discharging pollution into the river, if you want to use this analogy, are then taking their water downstream of that so that they realize that that they internalize the cost of their own pollution. And so that's why I have my crazy rationing ideas, which we can talk about later or now or whatever. But I wanna
Okay,
stop
we
there.
will. We certainly will. But I want to pick up with one of the questions you raised, which is if expertise sort of presumes we know what the expertise is directed toward, but there's the question, what are we maximizing? Expertise about what? What's the objective? And in a lot of this wonderful book, as in a lot of the criminal justice reform debate writ large, I think there's an assumption, and the assumption is twofold. First part of the assumption is the purpose of criminal law is public safety. Purpose of criminal law is to protect us and prevent crime. Second part of the assumption, the way we prevent crime, the way we do crime control is criminal law. And I want to question both parts of that assumption. Right? Is crime control the purpose of criminal law? Number one. I mean, we all know if we've sat through a 1L crim law course that it's not. That's not a consensus point, right? There's many
Four
competing
goals,
views,
right.
right? 4 goals of punishment, deterrence. Right? There's the utilitarian set, the retributive set. But for purposes of this,
Rehabilitation, add rehabilitation.
it's in utilitarian.
Right.
For purposes of this conversation, let's just take note of the fact that some people believe the purpose of criminal law is retributive justice, whatever you understand that to mean. Okay, maybe that means punishment, maybe that means a process of calling to account people who commit moral harm in the political community. But so there is this view that the purpose of criminal law is retributive justice, not crime control. Then on the other side, the way we do crime control is criminal law, as a number of people throughout this symposium have said. It's not at all apparent that criminal law is the most effective or even a particularly effective mechanism of doing crime control. So question to the panel, as we're thinking about expertise in the system, bringing expertise to the system, expertise needs a mandate. It needs to know what's the question to which we're bringing expertise.
Sorry, go ahead.
Let me finish the question and then jump in. First part of the question, how do we articulate a mandate for expert agencies in the criminal legal system without clearly defining the objectives of the criminal legal system? Second question, how do we recenter this whole conversation to ask more broadly, how do we do crime control without assuming that the answer is criminal law, and bringing expertise to that bigger question? And David, please go.
Okay, yeah, sorry, I'm just champing at the bit here. So one other thing that I would say, to be the left coaster here, is that there's another theory, is that criminal law is about social control. So we could say that, crime, we could all agree that, murder, rape, things like that. I mean, although there is a discussion about, like what constitutes rape. Bernard Harcourt again has said, the only sort of hard and fast criminal justice data are homicides, because you can't really fake a body or disagree about, the body is dead. But, crime is socially determined, right? It's not illegal for somebody to, well, it's federally illegal, but it's not illegal under state law if you're in Massachusetts or California to buy cannabis and smoke it, but it is, in Alabama, elsewhere, right? And I think that that's just an example of the way in which, the law is maybe not responding to things in the world so much as creating it, right? So you're saying we're defining something and then enforcing it. So that would be the one answer. But I think the answer to your second question, which I think I'm a little bit more interested in, is that if you look at some of the alternatives, there's one called the Good Lives model that talks about how it is related to crime and criminality, but it says, these are the sort of fundamental human needs that people need to have, and it does include things like security, and that can be housing, food security, personal security, and a variety of other things that are positive goals. And when those are missing and those are maladaptively, you try to fill those, that's when crime and criminality comes about. And I think that from my own perspective, I think, social justice and social welfare programs are, in the majority of cases. Now, this is why I actually am a fan of data. We can all get misled by the tails. The fat part of the bell curve, there aren't that many people who are just psychopaths, at least outside of 1600 Pennsylvania Avenue. But, so most people who commit crimes, like something happened, or they didn't have an opportunity that they had. I don't believe that I was born better. I think that I was in an environment that was a little bit more conducive to, obeying the rules such as I do. And so I would like us to think about what kind of lives do we want people to have? Like, what's missing? That might be another framework to look at it. That then, what kind of society do we want to have, and what role does criminal law play within that? Versus, what kind of criminal legal system do we want to have, and what effects does that have on society? So I'd like to make that a subset of a good society.
Do you want to jump in, Judge Saris?
Let me just talk for a minute about public safety. That is one of the goals. You're right, there are 4 goals, and not every goal is always consistent with the other. But if you're going to talk about public safety, there's an absolute role for data and empirical studies. And on the Sentencing Commission, we did the biggest study of recidivism, I think, that's ever been done. And we did an 8-year sweep of who recidivates. And somebody asked the question before, which was an outstanding one, which was, what does recidivate mean? And we looked at it from 3 points of view. Not just who gets rearrested, which is what the normal recidivism rate usually measures, but also who gets reconvicted, and probably most importantly, because it's a proxy for severity, how many people get incarcerated as a result of it. And if you look at that and then try and look at the crimes that we have against who's recidivating, and then look at, are they recidivating in serious ways, or is it just, I think someone said, well, the motor vehicle violation. I think you can do certain things with criminal justice that make sense or smart or whatever the word is. And the example would be, we took a look at career offender laws, and with the data, who recidivates with these 3 strikers? That's what I mean by the 3 strikes. And who actually is recidivating and how seriously. And actually, if you've, it's hard to define violent, but if you have somebody who is violent 3 times, has been convicted of it, they tend to recidivate more frequently than someone who just does a drug offense. And you might want to create drug policy based upon that. So that I think that there's always going to be, I think, an element of retribution, and that is something that is very hard to use with data. How serious is an Enron or a Bernie Madoff, or the driving in the HOV lane, or human trafficking? There are human judgments that go into that, but there are, if what you're really thinking is the primary goal, not the only goal, but the primary goal is public safety, data plays a huge role, and that's how the commissions have the greatest, in my view, value added when you have true professionals, statisticians, people from the academy, and criminologists. So that's where I would jump right in on that.
And did you want to jump in too, Kay?
I would just say that, going back to a lot of the state commissions, public safety was often written into the enabling legislation. It was seldom taken that seriously in the development of guidelines, especially those with a cap. They're developing a systematic set of sentencing guidelines that would do that cap was the primary goal. The commission initially in Minnesota absolutely eschewed any responsibility for public safety in the sense that they didn't think sentencing was going to matter a whit in terms of public safety. They said, the best crime control, crime control feature is a job. And that was the attitude, is that it was outside the realm of sentencing. And so the notion of using expertise research was not a big thing, other than broadly understood things that deterrence was about the immediacy of arrest or punishment rather than the length. I mean, things like that were well established and understood were brought into bear, but otherwise not.
That's really interesting to hear. And I think as a thought experiment, given that difference in perspective and given the fact that it is a political judgment whether the primary objective of a criminal legal system is public safety at all, what would it look like if instead of thinking about an expert agency to oversee the criminal legal system, what if we envisioned an expert agency of crime control?
Yeah.
Whose mandate was to reduce crime.
What was that name of that Tom Cruise movie?
Minority Report? Yes. Yeah, well, what would that agency's portfolio look like? How would we want to structure it? And where in its operations would the criminal legal system fit?
I mean, that's a great question. I think one of the questions we would have is, are drugs a public health problem or are they a criminal legal problem, right? And if they were a public health problem, then that wouldn't be part of crime control, except for the ancillary features of a non-legal market, where you can't enforce contracts except when you have a gun out. So, I mean, I think that would be interesting. I think, one of the questions that gets sort of caught up in all of this is, are we bringing, and this relates to the panel that was just before ours, who would have the control? So, you and I have talked about, in particular, like the Perry Preschool Project, and for those of you who don't know, this was a study in Ypsilanti, Michigan, and they looked at the lifetime involvement with the criminal legal system for kids who just had 1 year of quality education, preschool education, versus another randomly assigned cohort that didn't. And, the things that jump out are like 30% less likely to have ever been arrested. Okay, so on the one hand, you can say that would be great, that should be part of crime control. But on the other hand, you might say, take it out of crime control altogether and put it in education and an ancillary benefit, right? Like I don't want a DA deciding what the agenda is in terms of a preschool project. I can just say we should invest in this because it will result in lower criminality overall. But I think that question of governance and who really runs the show, and I think, no offense to anyone here, like it is sometimes hard to bring, at least I'll just say this in California because there are no one here from California. When you talk to prosecutors and judges in California, they know what the deal is, and you do not. And when you try to tell them something, they'll say, yeah, but it's not like that. I really have to throw the book at this guy just to make him show up in court. And you can say, well, the risk needs responsiveness principle by all these, criminologists says that you shouldn't throw the book at low-level offenders. You're just going to make them worse. And be like, yeah, but you haven't been to my court, right? So some of that, I think, would also be a cultural problem, depending on who was sitting at the table. And if it were, certain kinds of personalities, I think that might be difficult. But I'll let you guys.
Did either of you, if you have something burning to say, by all means. If not, I have another direction I'd love to take this for the last 15 minutes. Another fascinating thing about...
A half hour. I think we have a half hour, right?
But yes, but we're going to allot 15 minutes at the end for your questions. Fascinating thing about this proposal is in some ways it runs very much against the scholarly grain of the moment, in that a lot of other law professors, scholars who are writing about criminal justice reform see the primary problem with the system as a lack of democratic responsiveness, and they call for more democracy. And Professor Barkow's call in some ways seems like it's for less democracy. Is this proposal for expert agencies to exercise greater control and authority anti-democratic? Is it inconsistent with calls for more democratic participation in the criminal legal system? Kay, why don't we start?
Yes, I do think that that proposal is anti-democratic. And I think as a result, it's probably not terribly workable, because the government is not going to give up that control over sentencing policy, I don't believe. So I think it probably would not be terribly workable.
Let me clarify. Professor Barkow's proposal, it sounded like you thought the Minnesota Sentencing Commission had been a great thing. Do you see the
Yes.
existence of that kind of expert agency as counter to democratic participation in the system?
No, because we were basically working for the legislature. And in fact, I think framing that insulation question, really, instead of saying, how do you insulate the commission or expert body from political pressure, I think would be better framed as, how does a commission help a legislature insulate itself against political pressure that would be untoward? And I think that's what most of the commissions have done, is to provide the data, the expertise, and give that information and analysis to the legislature at critical points when they're considering legislation, when they're considering changes in sentencing, whatever, so that they have information that can counter policies that have no basis in anything other than somebody decided they wanted to propose it. So I think it's insulating the legislature, which I don't think is anti-democratic. It's just giving them tools that they need.
And Judge Cyrus.
I want to jump in because that's very interesting, because the U.S. Sentencing Commission is within the judiciary. I should have mentioned that often. We're within the judiciary, and you have to have so many judges on it. And so I don't view it as the proposal as anti-democratic at all, because as I started off saying, I never think you can completely insulate it from politics, because there's a level of society's judgment as to how serious rape is and how serious this crime is or that crime is. You don't want it to be completely outside. What you want to do is have a diverse enough membership, and that's one of Professor Barkow's proposals, that you represent different points of view, different philosophies, and you basically come up with something that's maybe not completely consensus, but which a broad brush of people can accept. And then if it doesn't cut muster, whether it's part of the legislature or there is an opportunity for a veto or for she suggests judicial review. There's some mechanism outside of it. And if it goes too far outside the range of what's rational. But I think at the end of the day, it's not either or, it's both. But you've got to have that expertise or that database to at least create not the crime du jour response. I was listening in bed the other night with my pillows propped up. I often flick on Fox because I want to understand what people are thinking, and I heard the Tucker Carlson attack on the First Step Act, and I heard that somebody committed a horrible crime, was released early, and I went, oh my God, here it goes. We need the Barkow approach to make sure they don't roll back the reforms that were taken. So I think it's a huge mistake to pitch this as complete insulation or none at all. I think we all have something to do on the moral judgments that go in, and that may make it messy, but that's sort of where it is.
I just want to add that, in case students have not had experience or other people have not had experience, in Santa Clara County where I live, which is home to Google and Facebook and many other companies you've heard of, the court system just transitioned from paper last year. Okay? So I think we're maybe getting ahead of ourselves when we talk about expertise, when you understand that, like, nobody has any information in Silicon Valley about the structure and the operation of the criminal legal system. And I say that because I think that I am one of those people who thinks that there should be local control, but there needs to be much, much more information. Journalists are not allowed to go into prison in California unless somebody uses up one of their personal visits. I mean, so there's a huge opacity to the system. And so, I mean, I think we're all in agreement that we can talk about what data means, but we should have something where we know what's happening. We don't actually know until, I think it's this month, deaths in custody in any carceral facility in the United States. There was a law that was just passed. It's starting now, like literally this month. And we should have that data, right? Like, somebody died under police or, jail or prison custody. So some of this is, I think we're talking about, like, yeah, and then, our dream house is going to have another castle, and then the third castle swimming pool. Like, what size will that be? Like, we don't even have a tent right now when it comes to data.
And just to add on the data was there was a reduction in penalties for crack cocaine at one point. And a key piece of data that no one knew was that there was no increase in recidivism, none, when you reduce the penalty. So that was then used for the next reform of, all right, let's reduce penalties in all drugs, because and again, there's been no uptick in recidivism. So just getting the very data that he's talking about can inform criminal justice policy in important ways.
You're both so right to make this point, because people who aren't in the system just never fail to radically underestimate how terrible the data is. Yeah, I do a lot of pretrial bail reform work. There's a lot of talk about pretrial detention. Try figuring out just what the rate of pretrial detention is in any jurisdiction. No one knows. So you're absolutely right, and it makes the point that expertise seems not just compatible with a more responsive, democratically accountable criminal justice system, but necessary to enable it, because we have to understand what the system is doing in order to make political and moral judgments about it. To that end, David, I wondered if you might talk briefly about some of your capping, rationing proposals to align incentives with decision-making
I mean, I
authority.
think the best example for this is after Plata, but for some really arcane reason, not in response to Plata, everyone wants to say, AB 109, which was realignment in California, passed. And what that said was that there was discussion about the correctional free lunch, and I've done some writing about this, that basically local officials decide who goes to prison in all but a handful of states that have what are called unified correction systems. Local officials decide who goes to prisons, but states pay for them. And we can talk about why the history of that is. It's basically like convict leasing. It used to be an economic asset. That's why the states wanted them. But now it's an economic drain, as most of you know. And I've done some empirical research in California, et cetera. And so AB 109 was basically a way of internalizing that. And that said, you can only send serious violent or sex offenders to California State Prison. Otherwise, if they are committing a felony, they are sent to the local jail, but what is constructively county jail, state prison. Yep, that's right, law students. It doesn't get any easier from here. So there's county jail, state prison, which will count for a prior, and then there's like jail, just county jail. And so you have people, initially that were serving, that are serving like 18-year drug possession, or drug distribution charges in Santa Barbara County Jail. And it's not set up for that. But the idea was, I think, and it's certainly consistent, is that eventually you hope that it's really Fresno County, will say, wow, we're bursting at the seams. We actually have to do something different other than continuing to arrest and incarcerate people, because unless it is a serious, violent, or sex offense, like, we're the ones who are going to be internalizing that cost. And one of the so that's the sort of proposal about some kind of hard caps, or as Kay was talking about, just sort of an ordinal ranking, right? If you're a judge who's dealing with pretrial, I don't care. Like, you tell me the 10% of people who are the worst, But it can't be that if you see people serial out and you're like, this guy's the worst. I mean, this guy's the worst. No, this guy's the worst too. And then so all of a sudden, 100 people are, every one of the 100 people you saw was 1 in 100, like the worst of the worst, right? And so I'm fine if you say, yeah, you get a certain percentage that you can use, and you have to decide. You have to make that decision. And this,
The judge decides? No.
well, I mean, so not always and not in all counties, but certainly when it comes to like, you know, other discretionary decisions. I don't want to pick on judges. I think it's, you know, parole boards do the same thing, right? Like, what's the risk of reoffending? And they don't necessarily have to think about the system. We think about cases. And when you think about cases, I think you are likely to say like, well, what if, in this case, something bad happens rather than what's going to happen systemically? And so the problem with that, though, is that, you know, Fresno's jails are unconstitutional. They're way overcrowded. I should, you know, and so what's going to happen with that? But I should also point out, like, little known fact, even though it's in the first paragraph of the Plata opinion, California stipulated that it was violating the Eighth Amendment in 2010, no, in 2001. And Plata was decided in 2011. So even though Rachel sees that as a big victory, that it was like, but the state is like, yeah, we're breaking the Eighth Amendment. What are you going to do about it? And your former judge said, this is a travesty of a disgrace because like people are finding these facts. And it's like, what was that, an Alford plea on the part of the state when they were like, oh, we're violating the Eighth Amendment? Not really, you know? So those are ways in which like, I think the system, it takes a long time for those kind of constraints to go out. And unfortunately, oftentimes what that means is that people are in really dangerous, overcrowded conditions. They're not getting any kind of services, et cetera, et cetera. So, you know, I don't know that that's the answer either.
Very briefly, before we turn it over to your questions, how did that cap come to be that was communicated to the Minnesota Commission?
Well, actually, the legislation was a lot vaguer than I indicated. It was sort of, please take into substantial consideration prison populations, current prison populations, and current sentencing practices. And since I was in charge of research, I decided to do one and not the other. And that's essentially how it happened. Because there's no way to recreate current sentencing practices when it's all over the map.
Yeah.
You can't do it. It's impossible. So I wasn't going to even try. And I thought, but prison population, I can do a simulation. We're going to collect the data. I can do that, and I want to do that. So that's what we did.
So while, of course, we print the money on the federal side, so we don't have caps. But one thing that we did do, we don't have the fiscal restraints, is we started publishing prison impact for everything. How many beds will this consume? And that actually started making a difference, even though we didn't physically have a cap. If suddenly you look at how much is this going to be in terms of bed space over time, that just knowledge has helped to inform decision-making. And there haven't been very many mandatory minimums, I think, in, I would say, 7 years. So it's really, I think, none that I can think of. So it's an important number.
And that might have been the inspiration for Larry Krasner in Philadelphia. I'm not sure how many of you saw
Yeah.
this, but he's directed his line prosecutors when they ask for a prison sentence to state on the record the amount of money and resources it will require.
And
which-
Missouri does that for judges too. Yeah.
Let's turn it over to you all for the last 17 minutes. Are there any questions? Yes.
So a few of you have talked a bit about how sentencing is like not the only answer to public safety, or perhaps not the primary answer to public safety. So my question is there a way to build expert bodies perhaps akin to the sentencing commissions, but that take into account other issues like affordable housing, like employment, like public benefits? And is there a way to like have those bodies actually influence legislation?
So I'm going to say something, and especially at, you know, since there are law students present, like I find probation officers to be really, really the most informed about like what's going on the ground, because they work with clients in the field, and they tend to say like, oh, this person did fail, but this person failed because the situation at home when they were under house arrest was really crazy, and there were 17 people there, and they just had to get out. Right, and so I think that there's an understanding on behalf of those people to say, you know, there's a huge housing crisis in California, as you probably know. to understand, like, you know, oh, this person keeps getting rearrested for what are essentially like crimes of homelessness, like trespassing and public urination and things like that. So I do think that there are criminal justice actors who know about that. I think there are judges who know about that. I think there are DAs who are committed to that and public defenders who are too. I think the question really is, like, ultimately, it's kind of a blocking and tackling issue where, you know, a budget is not fungible. You know, like the DA can't and really won't say, like, here's $5 million, you know, just you take it and build some homes with it or whatever, right? Like, that's never going to happen. And so I do think that there does need to be this question, you know, and that I would have responded to the prior panel, that, like, I do want to see ratcheting down the size of the system. I think that that's important, and I think it's really, you know, Justice Reinvestment has done some of that or has made that conversation clear, but this is all going to take place on, you know, sort of the state and local level. Right? I mean, there might be block grants from the federal government, but most of the action is taking place in state and local areas. And I think that when there's somehow this feeling that, like, the federal system is, you know, more impactful or better, it's really interesting and it's a big system, right? But there are 50 states and there are, you know, probably about 10 times as many people who are incarcerated in states and many more who are arrested and many more who are in jail and, you know, on community supervision. So I would think about that in terms of, like, these very, very what might seem technocratic kinds of solutions to say, like, how do we actually cut budgets of local, you know, law enforcement and then make the case that in 20 years this is, you know, going to pay off in terms of reduced crime?
I was going to say, in the bubbling up, we think about sentencing policy is coming top down, but truthfully, some of the most innovative solutions have come from judges and communities trying to deal with drug problems or veterans problems or mental health problems. They're coming up through these drug courts. As you said, it's quite correct, often driven by probation officers trying to find social services for people coming through. They're very professional on the federal level, and they're good at finding, oh, there's this day center and this halfway house, and we can try. But I have to say, one of the saddest things I do as a judge is I've been getting motions, please put an unopposed, please put this defendant in a halfway house because there's no home for him to go home to, and it's wintertime in Boston. So please, so that's basically by consent, essentially restraining liberty because there's no housing. And what we found, and you've made a great point in Boston, is we're at the lowest, if anyone wants to come work in Boston, we have the lowest unemployment rate ever in the history of our state. Anyone can get a job, but the housing is what's killing people. They can't find housing. You can't have a steady job if you're homeless. And so I think there is a huge, and then when you try and say, okay, well, we're going to lift the stigma of someone with a felony not being able to get into public housing, which we've been trying desperately to do, you get pushback because people have been waiting in line forever because there's not enough housing for anybody. And I think that really it is a broader issue because you cannot re-enter and have a lawful and fulfilled life if you can't have the basic things like housing is what I'm thinking of. And then everything falls into place. So if you, I would advocate for that. When Lyndon Johnson did his initial crime bill back in the mid-60s, that was one big piece of it, was like, let's look at the whole picture, exactly what you're saying. We don't do that anymore. We look at little fragments of it. And that's what you should do when you graduate.
Yeah, and just one addition is that after realignment, there were these things called the triple Cs. They were community corrections councils, and that had, you know, all the sort of DA, chief judge, you know, public defender, chief of probation, and usually the chief of probation was the chair of the organization, but it was designed to have some holistic planning. The problem is that, like, counties got to allocate the money that they got, you know, and that was subject to politics. But that's at least a model that could be improved on, and I don't know about other states, but California's done that.
Did you want to say anything there? No. Other questions? Quiet audience.
It's after lunch.
All
Yeah,
right.
I guess.
Could I
Have we
just
explained
say
everything?
One thing about North Carolina, because North Carolina just celebrated their 25th anniversary of their structured sentencing system, and they actually had a celebration. I did not go, nor did Tom Ross, who was the original chairman of that commission, but I see Tom a lot, and he said a couple of things about that. He did say that their structured sentencing system had totally taken contentious criminal justice issues off the table for the last 25 years in terms of it being a primary issue of debate in the legislature. And he also said that they were all convinced that while their prison population is still quite high, that it was much lower than it would have been without it. And he compared it with Georgia, for example, which did not have a similar structured sentencing system. And he thought that it had freed up money for other things in North Carolina that would not have been possible otherwise. And I just thought I'd relay that. I hoped he could be here today, but he couldn't. So anyway, that's North Carolina.
I have another question, if there are none from the audience, that I will ask you three, which is, I said earlier in the panel, expertise about what, don't you have to define the goal, and that's difficult, but one goal that everyone seems to agree on is reducing racial disparity in the system for very good reason. So the book talks about things like disparate impact assessments of policies. The question to you guys is, how can expertise most usefully promote the goal of reducing racial disparity in the system, and have you seen promising examples?
Yeah, there's this person named Sandy Mason who wrote an article called Bias In, Bias Out that taught me a ton about actuarial tools.
That's not the right answer.
It is totally the right answer. You should all read it. It's amazing.
Well, the obvious example is crack, where the law was put into place, and when the Sentencing Commission started to looking at the impact, you have to look at the racial impact of these sentencing laws. It was extraordinarily harmful to the racial to minorities, primarily black men, and it was really one of the primary movers on why we got to get rid of this thing. And I think to the extent that you do racial impact, prison impact statements, you can also look at racial impact of these prison of these sentences that we do, and I think that would make a difference.
Do any of you know any agency that does them routinely as a matter of course for policy iterations?
Can I just say we routinely look at the racial differentiations in different kinds of crimes. If you go on the website for every crime in the federal government, as well as in an aggregate way. So black, Hispanic, white, male, looks at gender and demographic differences. So it's a wealth of information to the extent someone would want to ever look at it.
It's certainly I think in most states, all fiscal impacts, I think, look at not just the number of beds or in fiscal impact, but also racial differentiation.
So, I mean, I'll say a couple of things. So one, there's a statewide law now about collecting data in California. And with the 1 year of digital data they have in Santa Clara County, they look actually at racial disparities, across, and it turns out they're relatively consistent across 4 different categories of crime. So, burglary and assault and things like that. One of the questions that, or one of the sticking points that is sort of a political question is that Santa Clara County gets no credit for doing that. Mm-hmm. All it's going to do is expose how the system works. Santa Clara County is probably better than many, many other places, but nobody else is producing that data. Mm-hmm. And so there's this perverse incentive just to hide things rather than to actually study it and try to make it better. And so that's one issue that exists with it. The other question that I sort of alluded to it in my opening statement is that if you look at, so let's say youth arrests for cannabis possession in Colorado, it's not arrestable in California if you're a youth, with stuff. So the absolute numbers have dropped probably, they're a tenth of what they were. But the racial disparities are still there. And I think that there is a hard question to ask, which is why does that persist, right? We know from the ACLU study that, on whites and blacks use marijuana roughly the same rate, but black people are 3.73 times more likely to be arrested than black people, 8 to 1 in Minnesota. I just happen to remember that. Mm-hmm. I love Minnesota. And so that's a really hard question. But on the other hand, do we want to, the gross harm has decreased over time, and that fewer people, a lot fewer people, kids of color, are being arrested for, cannabis possession in Colorado. So I'm uncomfortable celebrating that, but I also, so that's the question that I was sort of adverting to say, is it the gross number whose lives are not going to be as completely taken off track? That is good, in which case it's a total win for African American youth. But if it's about disparity, then it's just as bad as it ever was.
Can I say, one of the proposals in the Barco book was not just to have sentencing commissions, but also have commissions look at other aspects of criminal justice policy. And I think that's a really important thing. I don't want it to be lost here. I think we do sentencing commissions. Over half the states have them, the federal government does, and they've come with upsides and downsides. It's not perfect by any means. But one area I'd like to mention where we should probably do something like this is in the prisons themselves, is have some sort of expert bodies, because right now, at least the federal prison is within the Department of Justice. And while we were sitting in the Sentencing Commission, it was unbelievably difficult to get information, data coming out of the prisons.
Yeah.
And we were, at least, you can't believe what we had to go through just to get recidivism data. It took years, I'm not exaggerating, to get the authorities. I think that if you took it out of the Department of Justice, and like many states have independent departments and had some expert bodies looking at it, it's sort of the new frontier in my view. It's happening under the First Step Act, and it should be happening in every state, is looking at in the prisons, evidence-based, what works, what doesn't work, what educational programs are there, what job training programs, et cetera. It's right now just an impenetrable box to try and actually understand and use the evidence-based methods that we've actually, not perfect, but we've started to use in the sentencing area.
Along similar lines, something else I had meant to talk about was that, yes, the proposal for a centralized agency, not just a sentencing agency, but a centralized expert agency with oversight over the whole process. Criminal justice, as Professor Barkow points out, is relatively unique in that there is no centralized oversight mechanism. Other fields, environmental protection, occupational safety, we have a sort of a centralized agency charged with making sure the whole thing is operating as it should be, and that's just in most places not the case in the criminal justice system. You have these disparate stakeholders. Something that has been notable in my experience in criminal justice reform is I always hear from people who get a giant MacArthur grant or an Arnold Foundation grant is that the best thing about the grant is it brings everybody to the table, the DA, the defender, the courts, the police. And for the first time, they're all sitting in a room together talking about the system objectives. So is that really new? Had that not happened before? And why isn't there some form of centralized oversight?
Well, certainly, most of those actors get involved in a sentencing commission, but they don't necessarily deal with all the issues of all those positions. They've got a very specific, narrow goal in a sentencing commission. But they do sit down together in that sense. I think, though, if you were going to do a centralized criminal justice agency, I mean, I just see it as being probably at various times captured by one group or another. I think it'd be fairly bureaucratic, I think, unlike, say, with a narrower focus where you can really say, we're going to do this and we're going to do it right. I mean, just the nature of government is such that I think you'd have those problems with it. But
I would just say historically, because criminal justice is older and it was at a time when the state was much, much, much smaller and there weren't professional police for the first, 40 years of the country, and people got paid by the case if they were justices of the peace, et cetera, et cetera. We didn't have prisons first, we had jails. And then we gradually got state prisons, but we didn't have state prisons until, depending on how you want to count it, like Auburn in 1820. And so I think that might be some explanation of that. But I do also want to say that there are state and local, like air quality boards and environmental agencies. I think what's different is that there isn't the sort of cost passing from one person to another. And, if you send someone to get drug treatment or mental health treatment, the county pays for that. And if there aren't enough beds, they go to jail, right? And so there isn't this sort of shared resources or, the decision-making and the resource allocation they're not often the same, and in fact, they're almost never the same. And that is what I think is different about why we don't, and why it might make sense to internalize it all under one agency, as like the 5 very small states do with unified corrections, where there's just one system, one pot of money for everything from pretrial detention all the way through prison and release.
Can I say I'd be really reluctant to put it in to the Department of Justice? In other words, I would hate to merge the prosecution function with criminal justice with the sentencing function. I think there are other things I would do to the structure of the United States Sentencing Commission, but I thought it was an act of brilliance to put it within the judiciary, because constantly you're dealing with judges who don't have a particular stake. And anyway, I see the time.
No, it's great. We're getting into separations of powers questions, which are fascinating, but we're also at the end of our panel. So let's please join me in thanking the panelists for a wonderful conversation.